Flipped classroom is now a fairly well-known, widely used term in certain educational circles, giving students the opportunity when they come to class to do work, to actually engage in problem solving in productive ways, whether individually or in groups, collaboratively, and to solve problems and to apply the learning that you have acquired through your own research, through your own readings, and through your own use, accessing online materials, is going to be more productive than having 200 or 300 students come to a lecture hall to take notes.
I think it's a very good brief summary of what's the content of the lecture. Sometimes you'll miss the principles when hearing the lectures, and in videos you can pause it anytime and repeat it and then hear it again.
Firstly, I think that to have the first review of the lecture online is a good way to learn, because it's save a lot of time in lecture, and during lecture we can now have more discussion with our classmates.
And we might have some groups assigned to us, so it's going to be a really fun one because we're doing something really in daily life.
Of course our focus is duty of care, but I do want you to think about any other issues as well. At the moment when the classroom begins, presenting them with a problem, a common problem that they will all solve. They will all firstly brainstorm and discuss, and then attempt to solve, and then write about, and then present on, all in a 2-hour period.
We have a very nice hall, lecture hall, so that we can set up all these tables for hundreds of people. It's interesting for us to get involved in discussing with the students so that we know actually what kind of questions they will want to raise when they first see a problem.
It's an interesting experience, I think not just for the students but also for tutors as well. It's very much different from holding or conducting tutorials in a traditional in-class setting.
We as tutors were able to just dip in and out to help guide them with a gentle hand. They really took the responsibility upon themselves, not only to prepare for this session, but then to actively solve the problem and lead on each other in doing so.
If a hospital, in having been notified that there's a patient in trouble, they don't know his condition. So we don't need to say, is it foreseeable that a man with a heart attack will arrive? No, that's not the point. The point is he's there. Like you said, he's there.
They should have foreseen that they're negligent.
Today's large group class, we can have group discussions over specific issues. That is the way of applying some legal principle on the issue, on the problem. And we have practiced very little in the previous lecture, so it's a very good way for me to apply what we have learned into some real cases.
My opinion regarding this maths group class is very positive. I feel that it's very engaging and it really makes the students voice their opinions. And one of the best things about this class is that you have to learn to juggle different opinions, very stimulating, unsought opinions on the spot. And you also have to learn how to express your own opinions in the best way possible.
When you talk about your arguments, and then they will give your feedback and what they think, and sometimes they actually supplement you with their knowledge that maybe you haven't read about that in the book. And so I find it really challenging on one hand and fruitful when you discuss with the classmates.
It's proved to be quite, well, I shouldn't say successful, neither should I say yet effective, but it has certainly received the ringing endorsement of the students, who are about 96 or 97% in favor of continuing with flipped learning. They have provided a range of reasons why they feel their learning is more enriched, why it is a more useful, more valuable form of learning over a lecture, the passive lecture. We're moving forward and it will continue to evolve. But I'm quite satisfied at this stage that it was the right move, and I'm really happy to see students so keenly engaged in working with each other on the very material that I want them to master, as opposed to sitting there and taking notes.
Hello, my name is Julianne Jen, and I'm a principal lecturer at the Faculty of Law. I usually teach civil litigation in the PCL course, but I'm going to talk to you today about sale of goods contract. And the reason why I've chosen this topic to talk to you about it is because actually you may not think about the underlying principles, but actually you are involved or you are making a sale of goods contract maybe once a day, twice a day, every day. For example, when you buy a pen in a stationery store or when you buy a lunchbox at your school canteen, you are actually entering into a sale of goods contract. And that's what makes law interesting, because law is involved in every aspect of daily life. About specifically sale of goods contract, I want to go through with you what is meant by a contract. Now, unlike matters of public law, like criminal law where someone murders somebody and the government sues the murderer, contract law is a matter of private law and it's a matter between individuals. It governs the relationship between the private parties in the transaction. So, for example, if one party wants to seek recourse against another party in a contract, it will just sue the other in a court. The state will not be involved. A contract can be in writing, it could be oral or by conduct, or it could be partly oral, partly written, partly by conduct, or a mixture of all three. Usually, when we talk about contract, you think about a document or something that is signed. Actually, a contract is also created orally. So if I make an agreement orally with someone, that may be a contract. And actually, in relation to sale of goods, if you get to think about it, most of that is entered by conduct. For example, you buy a pen at a stationery store. You see it advertised or displayed at $5. You go and bring that pen to the cashier and pay the price of $5. The cashier actually accepts your $5. And by that time, you have actually entered into your contract. You don't actually have to say anything, and the contract has been entered into by conduct. What is also special about this arrangement is actually it gives rise to obligations which you can enforce, and this obligation is recognized by law. So, for example, if your pen doesn't work, you can bring it back to the stationer and you can ask for a refund, or you can ask for it to be replaced. So this is what a contract is about. I'm now going to talk about the legal ingredients of a contract. What constitutes a contract, for example? In Hong Kong, actually, we adopt a common law system. And we study the law embodied in cases because many of the judgments, which becomes precedents before us, are actually distilled by legal scholars. They will review the judgments and they will write some legal texts. And after they read all these cases, they have derived the law of contract and the legal ingredients to a contract into 4 elements. First of all, your contract must embody an offer. An offer is a willingness to enter into contract on specified terms. Now, earlier, when we talked about you buying that pen in the stationery store, we said the pen is displayed, and say, for example, if it's displayed for $5, is that an offer? Now, under the law, and when we read the cases, what we find out is actually the display for the pen for $5 is not an offer. Under law, it is called invitation to treat, which is an invitation to another person to make an offer to contract. At that time, when the invitation to treat is made, an offer is not made yet, because actually it's just like an advertisement telling you this pen is for $5. Okay, there is no intention yet to create any binding legal arrangement. The offer happens when you actually go and take the pen to the cashier. The fact that you take the pen for $5 is your offer to buy the pen. Okay, the offer happens when you take the pen to the cashier and offer to pay for it. And it's an offer to purchase the pen at the specified term, i.e. to buy it at $5. The other legal ingredient to a contract is the acceptance. Now, I think it would be easier for you to understand what the acceptance is. It is actually the cashier accepting your $5. Okay, the acceptance happens when the seller communicates that she is happy or she agrees with the terms on which you have offered to buy the pen. So you are buying the pen for $5, you offer her $5 for the pen, she accepts your $5 on the specified term, and there is where the acceptance has occurred. An important legal ingredient to a contract is consideration. Without consideration, there will be no contract. And the consideration is the benefits in exchange, the goods against the money. Both parties will have to pay a consideration. In your case, you are paying the money, the $5 for the pen. You part with your $5. And in the seller's case, the consideration is the pen itself. when it's selling the pen to you, it is actually parting with the pen. Okay, so both sides must have provided consideration under the contract, and this is a very essential legal ingredient. The last ingredient is the intention to create binding legal obligations. Okay, so by buying the pen and by selling that pen to you, you intend to be bound by this contract. If somehow you haven't paid for it, the seller can actually seek for you, against you for recourse for payment of the pen. And if the pen doesn't work, you can actually sue for the damages you have incurred as a result of the pen. Usually you won't, it's $5. You would take it back for a refund or a replacement. So with this together, these four elements, offer, acceptance, consideration, intention to create binding legal obligations, are the four important essential ingredients of a contract. So I have gone through the ingredients of the contract. In relation to a contract for sale of goods, of course, it relates to sale of goods. The seller transfers or agrees to transfer the property in the goods, and the buyer pays for the money consideration, which is the price. I've quickly gone through. Of course, I have basically gone through these principles in a simple manner. There are, of course, much more issues to be discussed, and of course, you will learn more about these issues when you actually study the law. For example, just by going through the issues, you may have some questions which spark off in your mind. For example, are the four ingredients the only things which one has to consider about entering into a contract? What about the capacity of the parties? You may be a minor, you may be under 18. If you go and buy a pen at a stationery store, are you bound by that contract because you are not of age yet? Or for example, phrases like, I offer to buy your iPhone for $100 and, unless you respond to me within 2 days, it will be a deemed acceptance of my offer. Can this happen? Okay, these are all some of the issues which you may learn when you are studying contract law. And again, this is why the law is interesting, because apart from legal principles, there are many, many issues or disputes arising out of these simple legal principles. And when we study the law, we are actually studying all these things. In answer to my question, because you may actually want to know, if I actually go to the store and buy something as a minor, will I be bound? Actually, the answer is yes. Okay, when minors actually go and buy goods which are deemed to be necessaries in their life. So what is necessary to a minor, for example, a baby, the necessary would be milk powder, okay? Or you, as a student, the necessary thing for you would be like a pen, right? And if you buy these necessaries, you'll be bound by the contract, okay? What is then, interesting to discuss is your iPhone, for example, may be a necessary to you today, but 50 years ago, or even 20, 30 years ago, is this a necessary? Okay, so what is interesting about the law also is it changes within time. Okay, what may be a necessary to a minor 20, 30 years ago may be different now, and we study the law which is up to date. Okay, and then in relation to my iPhone offer, for example, I can tell you your offer to buy someone's iPhone at $100 and deemed acceptance is not acceptance. Okay, if one wants to accept that offer, the offer or the acceptance must be communicated. All right, so silence, you say, oh, unless I hear from you, you are deemed to have accepted my offer, doesn't work. Okay, the acceptance must be communicated either in writing, orally, or by conduct. Silence is not acceptance. With students live, what I actually ask my students to do in the workshop is to actually try and think about drafting a sale of goods contract. And we go and work out, what are the terms we will include in the contract. So perhaps what I can ask you to think about is, if you were drafting a sale of goods contract, for example, what would be the terms which you would put in your contract? Okay. First of all, we will need to talk about what good are you going to sell, for example. Of course, that makes a difference. On one occasion when I was conducting this workshop, the students said, I'm going to sell a fountain pen. Okay. And I asked them, but in relation to this good you are selling the pen, or are you selling the ink cartridge inside the fountain pen, or are you selling both? All right, so one of the considerations is, of course, what is the product I'm going to sell, right? The others include, what types of terms would you include in the contract, okay? It's obviously quite important. I know you will include terms describing the parties, but what else? For example, On one occasion when I was doing it with a group of students, they said I wanted to sell ice cream. And I told them, so what are the terms you would include in your contract if you were a seller? And they said, I think I will include terms saying that, when the ice cream is stored in my store, the ice cream will be, stored in a condition where, it's, freezing temperature or -5 degrees Celsius. But as soon as I sell this ice cream to you, the buyer will take the risk, and the buyer needs to store the good in an appropriate environment. And if it didn't do so, or if it did not comply with this, then if the buyer subsequently suffers from stomachache or food poisoning, then the seller would not actually be responsible for this risk. So these are some of the things which you have to think about. It all, you may think, it's all about common sense. Well, it is, right? This is, again, why the law is interesting. We apply a lot of common sense into it. And you need to think, when I am thinking about drafting this contract, what is the good I'm selling? And what considerations do I need to take into account in order to come up with your draft contract? You usually see in a contract, I have listed here. Now, usually, where will you see these terms? I don't know whether you've bought things in a store before, which, say, for example, a television. Usually you get a receipt for your good, right? And usually for electrical stores or stores which sell big items like furniture, there will be actually some terms on the back of the receipt, okay? And some of these terms are what I've listed here, right? The essential ones, of course, are the parties, describing the goods which have been sold, the price, which is an important legal ingredient, the consideration, the payment, right, and how it's going to be paid. When are the goods delivered, right? And usually, the terms will include some warranties by the seller. A warranty is a type of guarantee that the seller or the manufacturer will undertake to guarantee the quality of the goods. Okay, for example, it could also be if the pen doesn't work, right, you can come and exchange it, or I'll give you a refund. When we are drafting a contract, we will also think about the eventualities. Okay, so we are looking at a long-term situation, and we will deal with issues where, for example, what happens if the parties do not adhere to their promises. So in your typical contract, in written form, you will also have things like jurisdiction clauses. Okay, if the matter goes wrong, where do I sue? And governing law clauses. Okay, if I was to apply the law to this contract, what governing law will I use? Usually if it's a Hong Kong contract, you will use Hong Kong law because, as you know, different jurisdictions may have different contract principles. Usually in your back of the receipt, you will also see what we call restriction or exemption clauses, where the seller will seek to limit its liability. And usually in such circumstances, the buyer may limit the damages paid to, for example, the price paid for the goods, or it may have a certain time for you to raise your complaint. So, for example, you cannot refund the goods unless you come to our store and do it within 7 days. So these are the common terms which you see in a sale of goods contract. I will then ask my students to go into groups and then try drafting one of the terms. And the usual term I would ask them to draft is the payment term, because that's quite simple. And students will then go off doing it. Maybe you can pause this video and do this now. When you've finished, look at your term and think about, have you dealt with all these, from whom is the payment going to be made, to whom, what, when, how? Now, these seem to be quite common, right? You deal with this when you're studying English, right? When you're drafting something or you're writing something, your teacher says, deal with this, who, where, when, what, how, why. These writing principles, skills, you actually also apply when you're studying law. And when you're thinking about drafting a payment term, right, think about all these as well. I mean, you may simply say the buyer will pay the seller $5, right? But for what it is paying for example, the buyer will pay the seller $5 for this whatever brand pen, whatever, whatever a number or whatever make the pen is. Or think about how and when. So usually you would think about something like the buyer will pay the seller for this pen at $5 by way of cash upon delivery or when entering into this contract. Okay, of course, if you're going to the stationery store to buy this pen, you won't draft this contract, but we're thinking about more big scale. Okay, if you're buying in bulk, if the payment price is millions of dollars, for example, you will then have to think, how this payment is made. If your buyer is internationally, it's an international contract, right? For example, your buyer or seller is not in Hong Kong. How are you going to make the payment? By check, by telegraphic transfer, by cash, millions of dollars. And also, if it's a large amount of money, you can also think about payment by installments. And you think about payment by installments, you also have to think how much, when, how many installments, and see if the other side agrees. Okay, so even drafting a payment term, there's a lot to think about. What I want to emphasize at this stage is that be sure and know about the fact that there is no right or wrong in drafting. Okay, so the importance is to make sure your client's needs are satisfied and the term works. Okay, if your drafting is different from your friend, it doesn't matter. Right? We emphasize on the effectiveness of your drafting and not whether it's the same as someone else's. Right? So when we are drafting a contract or whatever document in law, usually it won't be the same as the next one. Okay? Although we use a lot of precedents, right? But you're welcome to come up with your own term. And you can actually try yourself. Contract of sale of goods, right? We realize actually in daily life, our sale of goods contract is not in writing. Right? It's usually oral, and as I said, in a lot of the cases, it's actually by conduct, right? You going to buy the good. Then should we actually have a written sale of contract? Should we actually draft it, right? Is it essential to have this written document? I think, the pros for having a written document is obviously certainty, okay? As I said earlier, when you're drafting that contract, you actually think about many things, right? Even the payment term. We have to think about carefully. In minute detail, we need to talk about who, when, how it's paid, right? And it, in relation to two parties doing business with each other, having a written sales contract would certainly help to make the terms certain. We actually know what we are entering into. The benefit is also it deals with eventualities. If the contract doesn't work, right, what can we do? And it will set out what are the recourses, okay? And it will also set out what I can do. Maybe I can sue in the court. Maybe I can arbitrate, okay? In a typical sale of goods contract, the seller may also make some warranties, right, to protect the buyer, okay? So that is some of the benefits of having a written contract. What are the cons then? Well, when you think about it, earlier we talked about drafting a payment term. We haven't even put pen to paper, but we've discussed for 1 or 2 minutes what goes into the term. Think about when you actually draft it. You spend time writing it out. You spend time changing it, right? And if you're working in a law firm, you as a trainee or a junior solicitor may draft the term. Your partner or someone who is more senior than you may actually have to look at it. You will then have to send it to your client to make sure he approves the terms. So actually there's a lot of time spent and of course costs, right? In the legal world, time means costs. In actually drafting the contract, do you actually want to pay for that? It's also timing. Think about it. If you're buying a pen in a stationery store for $5, would you even bother drafting the contract? Okay, so usually we're talking about drafting written sales of goods contracts when it is a larger transaction, right? When the parties are entering into a much larger business, and we're talking about bulk buying or wholesaling. Okay, but there are pros and cons, and I think in ordinary life, a contract has been entered into, but you don't necessarily have to draft the terms. As I said earlier, when you go and buy goods, usually you will not enter into a written contract. And as I said, one of the benefits of having a written contract is, for example, the seller may give you some written warranties or guarantees about your good. What if I'm a consumer and I go and buy something, a television, for example? It's not a $5 pen, but I don't have a written contract. Well, don't worry, because actually the law offers us some protection, right? There are some ordinances. So these are written statutes, some provisions which assist consumers in Hong Kong. One of the usual statute or ordinance, which we will come to and we will learn about when you study sale of goods contracts, is the sale of goods ordinance. We call it SOGO. The other one is the supply of services implied terms ordinance, governing sale of services, so provision of services. both of these ordinances will offer protection to consumers. It implies terms into your contract about the quality of the goods or services, for example. So if you go into buy written contract, you just have a contract by conduct, for example. What happens is SOGO, Sale of Goods Ordinance, will imply a term or terms into your contract. For example, in relation to the quality of your television, SOGO will stipulate the television has to be of merchantable quality. Okay, so it has to be good quality so that you can actually watch TV shows. It will also stipulate that the television is fit for the purpose. Okay, so it's fit for the purpose of you watching the TV shows. It will also stipulate reasonable terms as to price and delivery. Okay, so it not only protects the consumer, it also protects the seller. Other ordinances, for example, trade description ordinance, ensuring the seller describes the goods accurately, for example, when it's making that invitation to treat. Consumer goods safety ordinance, as the name implies, concerns consumer goods safety. Exemption clauses ordinance, control of exemptions clauses ordinance and unconscionable contracts ordinances protects the consumer, makes sure the terms you enter into are fair. Okay? For example, as I said earlier, with a lot of sellers in Hong Kong, there are a lot of terms printed at the back of the receipts. Okay? These ordinances will say, in relation to any exemption or restriction clause, exempting or restricting the buyer's liability, these clauses will only be actionable, or they will only apply if they are fair. Okay? And one of the things which we use to decide whether these terms are fair is whether the buyer has notice. Okay? For example, I buy a television, and on the back of the receipt, it says, you can only complain or you can only make a refund within 3 days, 3 business days. And actually, I did not see the terms of this contract or alleged contract, because actually, I only got the receipt after I paid for the goods. Okay? So these ordinances will say, oh, actually, because the buyer did not have notice of this term at the time the contract was entered into, it only had notice afterwards, then these clauses are not actionable. So we are not valid clauses. Okay, so these are what these ordinances does. So don't be too frustrated that, oh, if I don't enter into a written contract, I don't get protection, right? There are a lot of ordinances under our laws in Hong Kong which protects consumers. Myself earlier, I'm actually a civil litigation lawyer, and my work involves helping my clients sue in civil actions under Hong Kong law. So the last thing I'm going to talk about is, what if a contract for sale of goods go wrong? Okay? Of course, if a contract goes wrong, you can always complain. Okay? I said in my slide, how will the contract go wrong? Well, it will go wrong in many instances. For example, you bought something and the quality is not good, or in terms of the seller, it sold something to the buyer and the buyer didn't pay. Okay? The remedies, as I introduced earlier, contract law is a matter of private law. So if matters go wrong, you actually complain, or as a consumer, you actually have the right to complain, for example, to the Consumer Council. Okay? If things go really wrong, of course, you can go to the court to seek payment for damages, okay, or seek recourse. Nowadays, what you can also do is to mediate. Okay, mediate is a private manner where the parties find a mediator to negotiate the settlement of the case privately. If your contract provides for arbitration, right, you can also arbitrate the case. Okay, arbitration again is a private matter, a private method to resolve disputes by having an arbitrator who is like a judge to determine your dispute. The difference between an arbitrator and a judge is a judge sits at a court. And in relation to arbitration proceedings, this is private. The parties will appoint their arbitrator according to the contract they entered into. Okay, so if a contract for sale goes wrong, usually you would make a complaint or you would sue in the courts. Thank you for watching this video with me. If you have problems, just contact our faculty and I'm sure they pass on the inquiries to me. Thank you.
Hello, my name is Jackie Young and I'm a lecturer of the Department of Law of the University of Hong Kong. In this particular taster session, I'm going to introduce a presentation called Safeguards Against Stereotypes in Criminal Proceedings to all of you. just in case you're interested in doing law in future at our university. Now, I myself is a lawyer, so lawyer likes to talk about disclaimer or reminder. So I have to give you a reminder in advance that we are, before I talk about the details of the presentation today, you should bear in mind that all these contents to be discussed are just general position of the law. So when you study law in future at HKU, you notice that all these principles of the law involve a lot of exceptions as well as exceptions to exceptions. Right. So what we're going to do today is that, as you notice, our focus will be on criminal proceedings. So I have to show you the difference or differences between civil proceedings and criminal proceedings. And then I'll introduce a concept called elements of offense to all of you. Right. So it's after we have understood what elements of offense are, then I'll proceed to the next topic about burden of proof and standard of proof. So it's about how to present these elements of offense to the court, right? And then we'll look at some common stereotypes which may exist in our community but are not applicable when it comes to court proceedings. Right. So the topics which we're going to discuss today would be relevant to several undergraduate courses of our LLB curriculum at HKU. So obviously we'll deal with something related to the criminal law when we talk about elements of offense. So it's something related to the criminal law and criminal law 1 and criminal law 2 of the University of Hong Kong LLB curriculum. Once you've completed the criminal law curriculum or criminal law courses, then in your senior year, you have a chance to to study courses like evidence and criminal procedure. So these courses are also relevant to something we're going to discuss today. Now, as I said, I'm trying to give you a brief overview in terms of the difference between civil proceedings and criminal proceedings. So as you can see on the slide, on the left, we have civil proceedings, and then on the right, we have the focus, that is criminal proceedings for today. Right. So let me just briefly talk about the differences between civil proceedings and criminal proceedings. Now, when it comes to criminal proceedings, it's usually the government initiating the prosecution, right? So, and the reason for initiating the prosecution is that someone has allegedly committed a crime, right? So we just call that a charge usually, right? Contrast that to the first bullet point we have on the side of civil proceedings. You'll notice that for civil proceedings, it's not a must that it's something initiated by the government, right? Let's say there's an injured party whose right was infringed, let's say a contractual right, right? Then it's possible for a private individual, or let's say for a company, to initiate an action and to sue the wrongdoing party or the allegedly wrongdoing party, that is the defendant, right? So this is the first difference. And another difference between civil proceedings and criminal proceedings is that when it comes to civil proceedings, the burden of proof is borne by both the plaintiff and the defendant. Now, obviously, as the plaintiff, as the person suing the defendant, obviously you have the burden or you have the obligation to show that there's a case for you to sue the defendant. But then at the same time, if you are a defendant saying that, oh, I have a valid defense in law, then you also bear the burden of proof to show the court that you had that particular defense. All right. Contrast that with the burden of proof issue in criminal proceedings. Right. When it comes to criminal proceedings, generally speaking, it's the prosecution bearing the burden of proof. So you, as a defendant, you don't have to prove yourself innocent. So it's the duty of the prosecution to prove that you have committed all the elements of the offense, and therefore you should be convicted by the court. All right. Another highlighting difference between civil proceedings and criminal proceedings is that when it comes to remedies, that is the outcome of the case. Let's say the court finds a plaintiff, the court finds a defendant liable in a civil proceedings, then it's possible to impose monetary compensation on the defendant, asking the defendant to pay a certain sum of money, which we call damages, to the plaintiff. sometimes you also see cases like injunctions. So these are something related to civil proceedings as well. Now, contrast that with the penalties available in criminal proceedings, right? So let's say a person is convicted of a criminal offense, then it's very likely that he'll be subject to some sentences passed by the court, which can be non-custodial or custodial. So examples of custodial sentences would be imprisonment, detention center order, and when it comes to non-custodial sentences options, fine, community services order, or probation order with some common types of non-custodial sentences. Right, so as I said, we're going to focus on our discussion related to criminal proceedings. Now, when it comes to criminal proceedings, obviously, as you could imagine, it's something related to crime, right? And there's so many types of criminal offenses in Hong Kong, right? Theft, criminal damage, murder, manslaughter, things like that. Now, when it comes to each of these crimes, we're going to, in the concept of criminal law, we're going to dissect these criminal offenses into different elements of offenses, right? So in order for a particular action or for a particular series of actions to constitute a crime, you must show that there are some elements of offense present in a particular scenario, right? So we call these elements of offense. So generally speaking, we can classify these elements of offense into two types. So as you can see on the slide, we have actus reus. Oftentimes we refer that to the physical element of the crime, all right? And then at the same time, we have mens rea, that is the mental element of the crime. So it's only when you have satisfied, or it's only when the prosecution can prove that a particular person has committed all the elements of offense, including actus reus and mens rea, of a particular criminal offense, then that person can be convicted of that particular criminal offense. All right. So I know it's a bit abstract, so I'm going to use murder as an example to show you the differences between actus reus element and mens rea elements. Right. So let's have a look at the first box. Now, these are the physical elements of murder. Right. As you see, if you want to prove that someone has committed murder, then there are some physical elements to be proved. So you have to show that there's a person committed an act or a series of acts which caused the death of the deceased, and then that particular killing was unlawful. So these would be the examples of the actus reus elements of murder. So it's not enough to convict a person because you still have to look at the mens rea element, that is the mental element of the crime. So if you're a prosecutor, you still have to prove that that person intended to kill the deceased or intended to cause serious bodily harm to that particular person. So it's only when all these elements, physical and mental elements, are fulfilled, then you can say that the court may convict a particular person. Okay, so having introduced the concept of elements of offense, then we'll look at the concept of burden of proof and standard of proof together, right? So just now I told you that in order to prove a particular crime, you have to show the court that a particular person committed the actus reus element or the mens rea element and the mens rea elements of the crime, right? So it's the duty of the prosecution when it comes to criminal proceedings. So we say that the prosecution bears the burden of proof, so it has the obligation to prove the existence of all elements of a particular criminal offense. So this is burden of proof. And then a related concept is called standard of proof. So here we're talking about to what extent we would accept that a particular party has proved a particular case, right? So when it comes to criminal proceedings, the standard of proof is that we'll adopt beyond reasonable doubt. So the court will have to, the prosecution will have to satisfy the court that, well, when presenting all these elements of crime by adducing appropriate evidence, appropriate pieces of evidence, that you can reach a conclusion that there's no reasonable doubt at all, and therefore the defendant ought to be convicted of that particular offense. So this is beyond reasonable doubt, right? Sometimes in layman terms, there is some layperson putting that as, putting the term beyond reasonable doubt as you must be sure that someone has committed the offense, right? So just in case you cannot understand the meaning of beyond reasonable doubt, perhaps at this level you make sure that, so you have to prove that that person must have done something. So you must be sure that that person has done something that is related to the crime, okay? Now, let's go to the main theme of today's topic. Now, as I said, having understood the issue of burden of proof, having understood the elements of offense, that should be enough to equip you with understanding this particular topic, right? Now, I'm going to introduce this particular topic with a hypothetical scenario. So have a look at the slide. You notice that, think about this, we now have a person called Donald, the defendant. He was arrested and charged with murdering his colleague Victor, right, on a particular date, on the 2nd of October 2017, right? Now, in Hong Kong, murder cases will be heard before members of jury. So it will be tried in the court of first instance in Hong Kong. So Donald will be brought to the High Court, and then before the jury and the trial judge, the case will be heard by the Tribunal of Facts, that is the jury, as well as the Tribunal of Law, that is the trial judge. Now, think about this. Let's think about this in our daily life, right? If a person has been arrested, and if that person says nothing after being arrested, do you think it is very likely that the person, do you think it's fair to draw adverse inference against that particular person? That is, chances are you may think in this particular way. So you may think, this person remained silent and he said nothing. He must have something to hide, and therefore he decided to say nothing, all right? So it's rather common that we would think about silence of a defendant in that particular way, all right? So we think that, just in case, or if he was really innocent, he could have told the police what happened at the material time. And therefore, by saying nothing, he is suspicious, right? So this is a very common stereotype against a defendant when it comes to criminal proceedings, all right? Now, but then this particular presumption or this particular stereotype runs against some of the fundamental principles in criminal proceedings. Remember I told you earlier that the burden of proof of proving guilty is on the prosecution, right? So the defendant does not have to show that he is innocent. So he has no obligation to say anything to the court or to say anything to the law enforcement agencies arresting him, right? And then another important principle is that in Hong Kong, being one of the common law jurisdictions, we have something called the presumption of innocence, right? So unless you have been proved guilty by the court, you are still innocent. So you don't have to do anything or say anything to prove that you are innocent, because you are presumed to be innocent, okay? So silence is one of the examples to show you that there may be some common stereotypes against the defendant in the community. But then when it comes to court proceedings, there will be directions saying that you, members of the jury, cannot draw any adverse inference on the defendant's silence, all right? And similar situation would happen when it comes to the bad character of the defendant. Now think about this. If you have a defendant standing in front of you, and the prosecutor just told you that, well, this particular defendant had 13 criminal conviction records before, right? Now, if we call this bad character evidence, so if this piece of evidence showing the bad character of the defendant is available to you, well, when it comes to our daily life thinking, it's very easy for us to come up to a conclusion that, oh, this is a bad guy because he has been committing a lot of criminal offenses in his life. And it will be more likely for him to be guilty of the current offense being tried. So he must be the killer of the deceased, and therefore he must be guilty, right? So again, this is another common stereotype drawn on the defendant's bad character. Again, it is a bit problematic because, think about this, just because someone had committed a lot of crimes or had involved in a lot of criminal activities before, does it mean that he had involved in the criminal activities for this particular trial or related to this particular trial? That may not be the case, right? And again, we have to bear in mind that the burden of proof is on the prosecution. So in order to prove that the defendant had committed murder in this particular case, you still have to rely on the relevant evidence adduced by the prosecution. So you cannot just rely on some rumors or evidence about what the defendant did in the past, or how bad the character of the defendant was in the past, to show that it's him committing the current offense, right? So, as I said, like the issue of silence, when it comes to court proceedings, you know that members of the jury may not have received training from law school. So the trial judge would have to give proper directions to members of the jury to ensure that they're not going to think in the way which we discussed related to the common stereotypes. So you cannot think that, oh, a defendant had committed a crime before, so it's more likely for him to commit the current offense. Or you cannot say that, oh, the defendant remained silent in court or remained silent to the law enforcement agency and therefore he must have something to hide. No, you cannot do that. So how are we going to prevent members of the jury from applying these, what we call impermissible way of thinking in deciding whether the defendant was guilty of a particular offense? Then we'll rely on something called the directions to jury. So in Hong Kong, we'll have directions given by the trial judge to members of the jury saying that, explaining the concept I've just told you, all right? Just because someone had committed a criminal offense before doesn't mean that he had committed a current offense, right? So this will be something, some directions related to the bad character of the defendant. But then at the same time, there will be some directions related to the silence of the defendant, reminding members of the jury that you cannot draw any adverse inference on the defendant just because he decided to remain silent in court or because he decided to remain silent out of court by not saying anything to the law enforcement agency. So ultimately, you have to rely on the evidence presented by the prosecution to prove those elements of offenses related to this particular case. Right, so through this particular taster session, I've given you a very brief overview of some key concepts when it comes to criminal law and evidence. So if you're interested in studying law, I hope I'll be able to see you soon at HKU, and I look forward to teaching you all in future. Thank you.